What can be arbitrated? Again, all commercial matters can be arbitrated, but there is a list which cannot be arbitrated, like matrimonial matters. Divorce cannot be arbitrated. Criminal issues, so you can't run away with the punishment by paying some compensation. Insolvency matters, anti-competition discussions, disputes, these things cannot be arbitrated, it has to be decided by the court. So, how the arbitration begins? The first step of arbitration is arbitration agreement. So, arbitration agreement, while drafting, parties can refer all or certain disputes to arbitration. They can also refer the dispute which is existing or dispute which may arise in future. That is why they use the term which have arisen or which may arise. So, all, certain, existing, future, everything could be referred to arbitration. So, this is the complete discretion of the parties. The dispute should be related to legal relationship, whether contractual or not. It is the same language what you heard under conciliation. The agreement should be in writing, it is mandatory. There were many questions raised that if not in writing, what happens? If not in writing, it is unenforceable, definitely not illegal. Unenforceable means you have to convert it into enforceable agreement and then follow it. So, therefore, oral arbitration agreement is not illegal, but it is only irregular. Again, to encourage arbitration, the legislature said that there need not be any arbitration agreement proper. Even if there is a suggestion made in one letter, acceptance is made in another letter, those two communications can be an arbitration agreement. They go one step further and they say that one person suggests arbitration, other person does not deny, arbitration agreement can come into existence. So, this is all, the idea is to encourage parties to go for arbitration, because the direct benefit falls on the court, because the court's burden gets reduced. If parties move towards arbitration, the burden on the court would come down. Once you have an arbitration agreement, it is going to have a quite compelling impact on the rights of the parties. First right which is taken away is your right to approach court. So, in spite of arbitration agreement, if the party goes to court, file a plaint, the plaint would be refused or it would be returned, and with the instruction that they should go before arbitrator. So, it is based upon a principle that a right created bilaterally, a right which is created by two parties, that is bilaterally, cannot be abrogated unilaterally. One party cannot cancel it, it has to be cancelled by both the parties. So, arbitration is a contractual right, you cannot cancel it alone, it has to be agreement between the parties to cancel arbitration. So, therefore, if a plaint is filed, the defendant can appear before a court and request the parties to send back to arbitration. Can a judicial authority refer them to arbitration on its own? The answer is no, it is only if the other party requests. If other party does not request, then it means that they have bilaterally rejected arbitration agreement. So, therefore, request from defendant is mandatory. Second consequence of this effect of arbitration agreement is interim measures from court. Before referring it to arbitration, before going through arbitration process, the parties can protect the subject matter of dispute by getting interim measures from the court. That is the great help that is provided under the Act. So, after arbitration agreement, after arisal of dispute, now we need to constitute a tribunal. How many can form a tribunal? It can be 1, it can be 3, but it cannot be 2. So, therefore, number is left to the parties to fix. The number should be uneven number, it cannot be even number. So, here the problem is split decision. So, when a private judge pronounces decision, if there are two different contradictory observations, it becomes unenforceable. So, therefore, they have to have odd number of judges, that is arbitrators. How the appointment is made is the parties who make an appointment. First they have to fix the number, single arbitrator or 3 arbitrators or 5 arbitrators. The number should be odd, how many not restricted. So, generally for the sake of discussion I will take 1 and 3 as the number. So, if there is a single arbitrator, the appointment would be done by the consensus of both the parties. If the parties cannot agree on one single name, then it has to be referred to Chief Justice, and the Chief Justice would make an appointment on behalf of parties. Simple process and there is no cause for delay. So, when you can make an application to the Chief Justice? So, 30 days time is given to the parties to decide on the name of the arbitrator. If they cannot decide within 30 days, make an application to Chief Justice. Chief Justice will appoint on behalf of parties. But when it comes to 3 arbitrators, there is a slight change in the process. First, they try to agree on 3 names. If not possible, then both parties will refer one name each, and both arbitrators would appoint one presiding arbitrator. So, if parties do not refer within 30 days, if the arbitrators do not recommend one name within 30 days, then same process, make an application to Chief Justice, Chief Justice will appoint on their behalf. So, when we talk about Chief Justice, who is this Chief Justice? Whether he is the Chief Justice of High Court or Chief Justice of a Supreme Court. He is Chief Justice of High Court as long as the arbitration is a domestic arbitration, where both parties are Indians, the subject matter is Indian, law involved is Indian. So, that becomes the Chief Justice of a High Court. But if the arbitration is international commercial arbitration, then the Chief Justice means Chief Justice of India, the Chief Justice of the Supreme Court. So, along with this appointment power, Chief Justice also enjoys the power to frame a scheme of appointment through which the appointment could be made. So, we constituted the arbitral tribunal. Then comes the question of jurisdiction. So, if there are 2 kinds of problems with jurisdiction. Jurisdiction, that is the tribunal functioning without jurisdiction, tribunal exceeding the jurisdiction. Exceeding jurisdiction means they start with a process within the jurisdiction, but during the process they exceed, they go beyond the scope of arbitration agreement. In both the cases, lack of jurisdiction, exceeding of jurisdiction is the arbitral tribunal who decides, and it is non-appealable. Once the court says, the tribunal says that they have a jurisdiction and then they will proceed with the matter, parties cannot question the decision with the court. This is another important impact of arbitration agreement. So, they cannot approach the court. Conduct of arbitral proceedings. So, once the arbitral tribunal is constituted, the process starts. First they fix the place of arbitration, then they have a choice of language, both could be decided by the parties only, and if they fail to do it, then it can be referred to other tribunals, that is arbitral tribunals. Statement of claim and defense should be submitted by both the parties on the agreed procedure between them. Hearing and written proceedings, here there is a departure from CPC. The arbitral tribunal can decide to have only written proceedings, no oral hearings. Whatever you want to say, you submit it in writing, it would be conveyed, copied, and copy would be supplied to all the parties involved, and there would be no discussion, oral discussion on it, and there would be award on those written submissions. The arbitral tribunal can take the assistance of the experts, or even they can take the assistance of the court to gain the attendance of witness. Choice of law. Which law is going to govern the arbitration? So, when I say law, I am talking about procedural as well as substantive law. So, when procedural law comes, the same rule is applicable, CPC, Indian Evidence Act not applicable. So, they are going to have their own procedure, they are going to have their own evidence law. But when it comes to substantive law, there are two kinds of arbitration. I mentioned it while discussing about Chief Justice. Domestic arbitration, when the parties are Indian, arbitration is in India, the dispute cause of action is in India, subject matter is in India, Indian law will govern it. So, here substantive law choice is not given to the parties, they are governed by the Indian law. But when the arbitration is international commercial arbitration, then the parties have a choice. They can choose any legal system and they could be governed by those legal system. So, that is the advantage of arbitration, that is choice of law. So, during this arbitration process, there is one important deviation from the process, that is settlement in arbitration. When I defined arbitration, I said the outcome of the arbitration is a judgment which is called as an award, but now I am talking about a settlement during arbitration. This is again an indication that the conciliation, mediation and negotiation are the best way to resolve commercial disputes. So, even during arbitration, the arbitrators can encourage parties to go for conciliation and settle the dispute. So, that is under section 30 of Arbitration and Conciliation Act. So, when you talk about forms and contents of an award, the award has to be in writing, that is for sure. It should be signed by majority, but one important aspect to be discussed here is reasons for the award. Till 1996, we were unanimous with our opinion that the reasons need not be given for an award, but here the reasons is made compulsory. Why the decision is going in favor of party A, the reasons should be enlisted, but earlier it was not necessary. But with it is with two exceptions. Exception number 1 is if parties do not want reasons, they can authorize the arbitral tribunal, do not give reasons, just give us decision. And if there is a settlement during arbitration, then as it is not his decision, he would not be in a position to give any reasons for that. And there is an interim arbitral award, there is interest and cost on the award. So, interim arbitral award is an award where rights of the parties is decided, but the dispute does not come to an end, but it will continue with other aspects of the dispute. So, once the award is pronounced, automatically the arbitral tribunal's function comes to an end. So, that is once a final award is pronounced, that is the termination of proceedings. There are other ways also in which the proceedings can terminate. Withdrawal of claim. If the person who has submitted the claim withdraws, the tribunal function terminates. But here one condition is there, that the defendant should not object. If he objects, then the proceedings will continue. Parties can agree to terminate through writing, through an agreement they can terminate the proceedings. Then arbitral tribunal itself can terminate if they find that the cooperation of the parties or the nature of the dispute is such that they cannot continue with the proceedings. So, with this there is an end to arbitral proceedings. Now, we have award in our hand, but if parties are not happy with the award, what they can do? Because award is binding on them and they think that the award is not correct. What is the remedy? The remedy is they can go to court and ask for setting aside of the award. So, setting aside of the award is based upon 7 grounds. One is incapacity of the parties. So, if you go through those grounds, mostly they all look like the defects with procedures. So, the court do not interfere with the award, but they will interfere with the procedure. First ground is incapacity of the parties. If the parties do not have capacity to enter into an arbitration agreement, no capacity to participate in arbitration agreement or arbitral proceedings, then the award could be set aside. Incapacity, Indian Contract Act provides all the capacities, but there are other legislations also which play an important role. So, those capacities should be checked. Arbitration agreement is void, then award could be set aside. Lack of notice. So, appointment of arbitrator, notice of proceedings, lack of notice which provides difficulty for the parties to prepare a case and present the case, this could be the grounds for setting aside an award. If the award is beyond the scope of arbitration agreement, ultra vires award, the award is not within the terms of agreement, not contemplated by the parties, beyond the scope of the agreement, the award could be set aside. Composition of the arbitral tribunal, if it is not according to arbitration agreement, award would be set aside. If subject matter is not capable of arbitration, award could be set aside. And the last one, the most important one is, if the award is against public policy, then award could be set aside. Then there is a last resort. After arbitration, you go for setting aside. After setting aside, you go for appeal. Now, this is the last stage in the arbitration process. So, when you go to appeal, you can go in appeal on 4 grounds. Number 1, interim measures ordered by the court. You can go against it, you can go for refusing it, you can go to court in appeal. If the application for setting aside is made and the award is set aside, you can go in appeal and request the court to relook into the decision. And application is made and it is rejected, then also you can go for relook into the decision. There are certain decisions of the arbitral tribunal which could be appealed, like jurisdictional issues. If the arbitral tribunal decides that it has no jurisdiction, please remember, it has no jurisdiction, only that matter is appealable. If it says it has jurisdiction, it is non-appealable. Interim orders, interim measures taken by the arbitral tribunal, they are appealable. So, these are the provisions in which appeals could be made. So, this is my brief discussion on conciliation and arbitration. I request you to contact me through the forum which has been established under this whole process. I would be very happy to help you out in case of any queries. Thank you very much and all the best.